press conference with the governor intervening and others giving him a special dispensation. And so here is this great generation where black folks and white folks in this country joined together. They fought, and they bled, they died. Goodman, Cheney, and Schwerner are dying for voting rights. They grew up at a time when the states like South Carolina routinely placed these burdens on the right to vote and made it impossible and even dangerous to try to cast these votes. I don't know if you see that this isn't that much different in terms of the cost to this person of trying to ultimately pay to do what was in effect a poll tax. Now my time's about to run out, and I want to say you can answer after this because I've only got a minute and 30 seconds. So let me just conclude, and then I know they'll ask you this, but this isn't complicated to me, sir. Costs like this create structural barriers that systematically disenfranchise African Americans, people of color, and actually poor people of all colors. I'm concerned that a person who believes that we are all one race, like Scalia says, in the eyes of government, that could happen months from now, a couple of years from now, a person who believes that efforts to promote racial justice are, your words, naked racial set-asides, that will be blind to the reality of someone like Mr. Butler and the experiences of poor folks all around this country. You refuse to answer a lot of my questions about your views of the race and the law, talking about what Supreme Court precedent is. We are at a time when states are enacting these laws all over our country, designed to disenfranchise voters. As one federal court said about a North Carolina law, targeting them with almost surgical precision to disenfranchise them. And now we don't even have the benefit of the Voting Rights Act provision designed to curtail the they go into effect. Your answers don't provide me comfort. As a justice of our nation's highest court, that you will fairly take into account the barriers that continue to disenfranchise minority voters like Mr. Butler today. Sir, I'm an optimist. I'm a prisoner of hope like you. We have a long way to go. We have work to do. Black folks and white folks honoring the history of a united America fighting to make us more just. The Supreme Court has a vital role in that. And nothing you've said here today gives me comfort. Gives me comfort that should you get on the Supreme Court, that you will drive forward and see that we have that work to do and make the kind of decisions that will make a difference for people like Mr. Butler, people living east of the Anacostia River, north of the river, south of the river, all over this nation. Thank you, sir.
Can I take a minute to respond?
Sure, and then I'm going to recognize some for the
Senator, a couple things on that. I pointed out in the South Carolina opinion, I wrote the majority opinion that we see on an all too common basis that racism still exists in the United States of America. The long march for racial equality is not over. I cited, I think you've seen after an African American hockey player scored the winning goal and a burst of racial commentary about him, and that was just one of many examples I could have cited in that case.
Racial commentary, can you be more specific?
Okay. Racist. I should have said racist. Racist comments is what I should have said online. And that was just one example I pointed to say the reality, just one example. I made clear that the reasonable impediment provision had to be rewritten. I was all over the real world effects during the trial that you're raising here. I was all over that. So were the other judges of how's this really going to work in practice? How's it we drilled down and drilled down and drilled down and caused the rewriting of the reasonable impediment provision to make sure. I talked about the fact, for example, that African Americans in South Carolina at that time didn't have as many cars on the same percentage, and so to get to your point about getting the photo IDs, I made clear that I understood that. We blocked implementation for 2012 because we were worried, to your point about the form, that it wouldn't be enough time to get all this in place and to educate people. It was a unanimous decision. Again, neither side. The Obama Justice Department did not appeal our decision to the Supreme Court. I assume that's because they thought our decision appropriately accommodated the interests of the parties in that case and would ensure that African Americans in South Carolina were able to vote on the same basis as before. I'm talking about my life and record. We were talking about that. Going back to growing up, like the Wall Journal note that I wrote on race discrimination talked about something that I know you've been talking about a lot, which was bias in the criminal justice system. And I said at the end of that Wall Journal note that both racial equality and the appearance of racial equality were critical to the fairness of the racial justice system. I provided specific mechanisms for rooting out race discrimination in the jury selection process. and talked about what you've talked about, implicit bias or subconscious racism. I specifically talked about that in that decision. I've been I think, a leader. So there's 2010 testimony before the Congress about the lack of minority law clerk hiring at the Supreme Court, and Justice Thomas and Justice Breyer were testifying before the Appropriations Committee, and they were asked about minority law clerks and the lack of them at the Supreme Court. And they said, in essence, well, we're hiring from the lower courts. And I remember reading that and thinking, well, I need to do something about that. I'm the lower court. I'm one of them. And so after that, I thought, what can I do? And I didn't just sit there. I went and thought, what can I do? And I started on my own going to the Yale Black Law Students Association every year starting in 2012. I think I'm the only judge who's done something like that, or certainly one of the few. And I just cold called them, cold emailed them and said, I'd like to come speak about minority law clerk hiring because I'm told there's a problem there. And I showed up the first time wondering how it would go. And I explained, and I got a good crowd from the Black Law Students Association. I said, we need more law clerks. There's a problem. And let me tell you how to do it. And here's why you should clerk. And here's how you clerk. And here's how you, here are the classes you should take. And here's the things you need. And at the end of that meeting, I gave them my phone number and email and said, call me anytime, email me anytime if you want help. And then it was a big success. I got a lot of emails after that. I helped students get clerkships with other judges. One of them recently finished the Supreme Court, emailed me thanking me for starting him on that road. And then it was a success, and I've gone back almost every year there. And as you know, we're graduates of the same law school. That's a lot of people clerk from there, so it's a good place to go. And I've continued to encourage African-American law clerks, but it's not just encouragement. I've given them help and advice and been a source of counsel. I've tried to be. And why is that? Because I saw a problem to the extent you're of the kind you're talking about. And it's one small thing, I suppose, but those are the future people who are going to be sitting around here and sitting here. I think those are the pool. And I've tried to be very proactive on that, including my own clerk hiring, where the old networks that prevented women and African Americans and minorities from getting law clerkships. I've been very aggressive about trying to break down those barriers and be very proactive on that, recognizing that part of this is professors who have research assistants. And so I've done my cases like the E.C. Ito case and the Ortiz Diaz case. And I think the South Carolina case, I understand your concern about, but I'm proud of what we did in that case. So I think if you look at your broader question about my life and my record, I understand what you're asking about a few comments in the Hawaii case. But if you look at the sweep of it, I hope it gives you confidence that I at least done my best to try to understand the real world and try through my actual decisions to understand the real world and apply the law fairly, and through my other role as a judge and hiring law clerks to be very proactive in trying to advance equality for African Americans.
Senator Lee.
Sir,
Senator Lee.
Mr. Chairman, thank you. I think it's important. The rules of fairness and the rules of the committee require us to treat our witnesses with respect, with certain minimum standards of respect, such that you can't cross-examine somebody about a document that they can't see. Now, in this circumstance, the document that was referred to by my distinguished friend and colleague from New Jersey, Senator Booker, was designated as committee confidential. Now, there are ways we can deal with this. We can deal with this either in a closed session so that he can see the document to which you're referring, or we can also go about different procedures to make it public. We've already done this in this very set of hearings with Senator Leahy and with Senator Klobuchar, who identified some documents that were identified as committee confidential. The one thing we cannot do is refer to a document, cross-examine him about that document, but not even let him see it because he can't see it. We wouldn't do that in a courtroom, and we can't do that in our committee. Our rules don't allow it. So I would just suggest that we go through the proper procedure to either deal with this in a closed session, or ideally go through the process that Senator Leahy and Senator Klobuchar went through in order to allow us to address this in open committee.
The objection is duly noted, 30 seconds.
I really respect my colleague from Utah and I appreciate that. I'm not the first colleague that has referenced committee confidential emails, not the ones who said that the exception has been, they were referenced before. And that's why this system is rigged, is because we have been asking, I have letters here, sir, that have asked for. Now, the one email is specifically entitled racial profiling, but somehow, I mean, literally, the email was entitled racial profiling. That somehow was designated as something that the public couldn't see. This wasn't personal information. This wasn't personal information. There's no national security issue whatsoever. The fact that we are not allowing these emails out, as we have asked, as I have asked, joined a letter with my colleagues asking, and that's why I'm saying the system's rigged. More than that, Senator, you have this system where this whole areas of his career where
Senator, you can begin to wrap up.
I will wrap up. Thank you, sir, for the generosity. With this whole areas, we're not allowed to let these out. And so I see you're outlining a process, but I'm saying that process is unfair, it's unnecessary, it's unjust, and it's unprecedented on this committee.
Okay, gentlemen, I'm trying to be fair to everybody. I know Senator Lee wants to respond. With respect, if you would do that briefly, I'd like to continue on.
Senator Booker, I will go with you hand in hand, literally, to work with committee leadership staff to get that going. I agree with you. There's no reason why it shouldn't be something that we can discuss in public. I don't know why it was marked committee confidential. Wasn't in charge of that. Regardless, we do have to follow a procedure so that he can have access to it, so that he knows how to respond. I'll work with you on that.
Thank you, gentlemen. I'm next. And I don't have an email. I want to start, I watched you for the last couple of days, Judge, and I want to compliment you on your demeanor. And I mean that. I know you're on your best behavior, but I appreciate your humility.
No, this is not a news show. This is the Blackie Fitzpatrick Show, slowly signing out. I do pay attention to the news, and it's 5 o'clock in the morning in Vienna. I'm going to say bye-bye. Thank you, guys. For the people who find me tomorrow, that's fine. Usually, this is a untimed late-night show. And thanks for everybody who's watching me. Hi, guys. It's 5 o'clock in the morning in Vienna, and I'm going to say bye-bye from the Blackie Fitzpatrick Show. Am I political? Yeah, a little bit. I like to watch politics as a sport. If I thought I was a professional, I would be a fool. And what a fool believes, I say bye-bye, the Doobie Brothers.
Anybody else would you? Don't you know?
So now I'm alone. Now I can think for myself. About little girls and rescues. Things that I just don't understand. I forgot right in my head. So I tell you tongues. I don't think I'm an anything for you. Hey, that's not lovely. I should never have trouble. Listen, they'll turn it over. You see, when everything's